Well, hi again, everyone. It's Rob Ryder on Tuesday, the 17th of December, 2024. And today, J.D. Vance, BANKERSPLAIN, APR by Actuarial Method, as that term is used in 15 U.S.C. Chapter 41, Subchapter 1, Consumer Credit Cost Disclosure. And since we're talking about that, sir, why do senators allow the agency, CFPB, to usurp a legislative bureau? So what is Redlewski talking about today? Well, this goes back to the truth in lending that we've been talking about here recently. And the fact that, of course, after a closer review, the document that they give you does not meet the law. And the agency they send you to is not the agency in the law that says you're supposed to go to. The administrative state strikes again. And apparently senators can't do anything about it, JD, because here we are. This has been going on for 15 years now. I mean, this was from 2010. So I'm saying you need to put on your frickin' Marine uniform and go as Corporal Vance over to a general court-martial convenient authority and file some charges and specifications for fraud against the United States, which is a military crime, and make it military. I've shown in these other videos I did about you that you really don't have any power as a senator because you didn't take the proper oath. You'll see that soon enough for yourself, but so that doesn't help the rest of us out. I mean, we got to get this shit figured out. And you guys write a law, and it says to create this particular bureau, and instead, a agency is usurped in place of the bureau. And of course, all these words have meanings, or why would we use them? Why would you call it a bureau unless that's what you meant it to be? So we're going to get into exactly what a bureau is and so forth and so on. And then I want to show an ongoing case where these things would apply, having to do with the United States Department of Agriculture mortgages, USDA loan. And so the one I'm working on, the person involved is a little older, not in really good health, doesn't want to push the envelope. And, I understand so much, but we can't go any further unless we're going to rebut what they're doing. And so if you have a newer loan where you can find all the information, then one of the things we're talking about today is, well, what are you supposed to do about this stuff when it's wrong? And as it turns out, the USDA is FDIC insured, and so they're under the FDIC. And I'd say it's the same with the VA loan. So if you have a VA loan, I'm asking if you have a newer one because it's easier for you to find the paperwork, which is, basically go to the closing agent on your closing disclosure and tell them you want an electronic copy of the file. There'll be a file number. I'll show you a little bit better in just a minute. And tell them you want a whole copy of it and then send it to me. If you don't mind me showing it, I will. I'll try to keep your personal information out of it, but I could make a mistake. And God, your name may show up or an address or something else on some form that I forgot to black it out on. So there's always that error. There's always that, that situation. But I'm okay with it if you are. Now, who am I? Well, I'm Redlewski Robert Allen. DOD ID number 12112800006, sir. You can find me in the book. All right, go to the DOD, look me up. Or you could write me at quarterrecord@AOL.com. And as I said, I have done a couple other videos directed to you, JD, and you can find those on YouTube at Rob Ryder, ROBBBRYDER, or on Rumble at Rob Ryder, ROBBRYDER. Sorry for all the mistakes, but, it's a one-man show. Been going on a lot of years. Just easier to overlook them and continue on. Okay. Give me just a minute here and let me show you a thing or two. Yeah, so just real quick, Rob Ryder. Right, there we go. J.D. Vance enlistee and J.D. Vance U.S. Marine. Get a minute, have somebody watch those. Okay, so one of the things we'll be talking about, it has to do with Public Law 111-203 from July 21st, 2010, which is also known as the Dodd-Frank Wall Street Reform and Consumers Protection Act, which tells us in its 849 pages, let's see, page 581, it tells us that there's going to be a Bureau of Consumer Financial Protection. All right, so now we got definitions. So what's the definition? Bureau. What's the definition of a bureau? Bureau means Bureau of Consumer Financial Protection. Okay, remember that. So again, the law mandates a Bureau of Consumer Financial Protection, and what we have instead is a Consumer Financial Protection Bureau, which says it's not a bureau. It says it's a U.S. government agency dedicated to making sure you are treated fairly by banks, lenders, and other financial institutions. That sounds wonderful, but it's an agency. It's not a bureau. And there is a difference. All right, this is Webster's 1828. He says it's an ambassador's or secretary's office, or in Spanish, the word bureau is a court of justice for the trial of persons belonging to the king's household. All right, so if you're under the Constitution, it's a court of justice for us to go to, or it's supposed to be. But we don't have a bureau. Instead, they say we have an agency. What did Webster say about that? The office of an agent, factor, business of an agent, entrusted with concerns of another, principal pays the charges of an agency. Well, that don't sound necessarily like that's a court of justice at all. So what happened, JD? Why did Congress say, look, we want a bureau, we want it to be the Bureau of Consumer Financial Protection, and we got stuck with a thing called the Consumer Financial Protection Bureau, which is actually an agency, which is one of the agencies that Elon Musk wants to get rid of, and it's for obvious reasons, right? Because it's not what it says it is. It's a fraud against the United States. Go report it to the fucking General Court Martial Convening Authority. JD, General Court Martial Convening Authority. Go look up the UCMJ, see who that is. Go find one, go talk to them. Go file charges and specifications. All right, we don't need to DOGE them, we need to bury them as an enemy of the United States, and the shit will start clearing up a lot quicker. I mean, you can go even to Wikipedia. Okay, they call it Consumer Financial Protection Bureau, CFPB. That's what we're used to, right? An independent agency of the United States government. Yeah, we just read that. They said it. But look what seal they use. The Bureau of Consumer Financial Protection. And this is, this is actually something that's supposed to be within the Federal Reserve, because the Federal Reserve claims to be the parent agency. So then, can you have an agent of an agent? Why don't we go to the Federal Reserve and say, hey, we didn't ask for an agency, we asked for a bureau. And, pull a couple of them out of their chair, take them down to the holding cell. They'll start talking, and you get all sorts of information. And then you can go to the Federal Register just to show you how screwed up shit is. And here it says the Bureau of Consumer Financial Protection, which is the proper form of the name, but it's not CFPB. It would be BCFP. So the right name with the wrong acronym is an independent bureau within the Federal Reserve System that empowers consumers, So are you telling me then that if I needed to get a hold of the right office, I need to call it the Bureau of Consumer Financial Protection in the parentheses NCFPB? Is that, because that says that this, whatever this is, if you're just looking at words, these words here is an independent bureau. It doesn't say it's an agency. Other places, when it talks about the, Consumer Financial Protection Bureau, where the name matches the acronym, well, then it's an agency. Just pointing out everything I can, JD, to show you how screwed up the system is, and you're not going to fix it from where you are in the fictitious constitutional government, because none of you people took an oath of office over there. But you, sir, did take an oath of enlistment, and it's still valid, and you're still in, so go file some charges and specifications. Take Pete Hegseth with you. He can, be the commander. Let him sign off on it. Right? You're looking for the signature of a commissioned officer, JD. That's all you got to do. You got to get the signature of a commissioned officer, and the rest will take care of itself. Right? But you need to go file the charges and specifications and swear to your complaint before a proper officer according to the UCMJ. They got a list of them. Da-da-da-da. Just file the book. Well, one of the things that comes out of that big-ass law is the chapter to do with consumer credit cost disclosure, which we would have called the truth in lending disclosure statement at one time, but now it's the closing. Now they have, I think it's the closing disclosure. Right, that's what they call it. You don't have a truth in lending. It used to be you got something like this. All right, this is from, the Department of Agriculture. But it's a truth in lending statement. It doesn't say it's a truth in lending disclosure statement like the law says it's supposed to say. So this really isn't the right form, and that's one of the things we're going to look at here is that, they don't even use the right form. So if you do have a relatively new loan, right, USDA or VA, I'd like to see what a VA one looks like too, right? Find your closing disclosure, go to settlement agent, they'll have that. You can get the file number. You look on here on another page, you'll find their email address someplace. I think it's down here. In here, they got all the contact information for who's who, right? Email address. I'm just asking for a copy of all the documents, electronic copy of all the documents having to do with whatever this file number is behind here. And send me a copy, and I'll tell you what it says the best I can. I can't do a whole bunch. I mean, if I get more than a couple, then you're all going to just have to, watch and see what I found. And so, if we go to page 6, just, right, same thing, that the Bureau means the Bureau of Consumer Financial Protection, not the Consumer Financial Protection Bureau, but the Bureau of Consumer Financial Protection. It says the board refers to the Board of Governors of the Federal Reserve System. Well, that's their proper name. So apparently the Bureau of Consumer Financial Protection is the proper name of the Bureau, but that's not the one they tell you to go to. And the reason it's so very important is that all through this document then, it's going to say that whatever's being done is being done by the regulations of the Bureau. So it's really important to know, well, who's the Bureau and do I have the right documents? One of the things is, I tell you that the annual percentage rate and financial charge disclosed more conspicuously than the other terms, which is normally how they are. They look like this. Well, this one isn't, but these two are darker. Or excuse me, annual percentage and financial charge, which are really the only two that the law specifically says how they are derived. Whether it's done right or not, it's yet to be determined. And eventually then you get to transactions other than under an open-end credit plan, which is like a credit card. So anything other than a credit card, these are the required disclosures by the creditor. And, you got the amount financed, which shall be the amount of credit which the consumer has actual use. The amount shall be computed as follows, So, amount financed, is that on there? Yeah, we got amount financed, got finance charge, annual percentage rate. These are all words that are going to have terms that are going to have some kind of definition in this law. But one of the things that it says to do is that in conjunction with the disclosure of the amount financed, the creditor shall provide a statement of the consumer's right to obtain, upon written request, a written itemization of the amounts financed. Written itemization of amounts financed. Well, there you go again. Itemization of the amounts financed. Well, that's what it has to say. It's got to be in them parentheses, them words. And let's see. If we had that, yes, I want an itemization. Check. And then itemization of the amounts financed. Now look at this thing, right? There's $133,000 apparently, but none of it's been allocated to anybody. But according to the law, it has to be. Right? The amount that is or will be paid directly to the consumer. The amount that is or will be credited to the consumer's account. The amount that is or will be paid to third persons. What are we looking at here? Well, there's none in my account, none given directly, none to any other third persons, not a creditor, not another, not a public official. Only $110 prepaid finance charge. Well, that's interesting. Well, where'd that go to? So anyways, this is what, a homeowner has that was supposed to be, one of the starting documents, foundational documents of their loan through the United States Department of Agriculture, and it's just all full of frickin' errors and omissions. Here's another one we're going to see where you're supposed to tell you about the payments and so forth. When payments are due, that's what's supposed to be here, and they put one date. So you're supposed to make all the payments on 9/21/2006. There's 456 payments. And it says how much the payments are supposed to be. Well, here's one of the bills for that account, and it's close, but it's not it. 746.10. Right? So they intentionally didn't use 764.24, which it says that's how much it's supposed to be. Well, why are they telling you to send less money then when they send you the bill? Right? This is the bill sent to the homeowner. Pay $746.10. But that doesn't seem to have a damn thing to do with what's on this statement. And to make matters worse, right? Now here's another month. This is a more recent month's payment. Here they ask for $675.03. Why is the USDA not asking for what was agreed to according to the document that's supposed to be the truth in lending document? But it's actually supposed to be a truth in lending disclosure statement, and this just says it's a truth in lending statement. So I'm saying, well, okay, that explains a lot. This is a counterfeit of a disclosure statement, but it's really not the right deal. So help me out with that, JD. So anyways, I want to take something like this now, seeing this, to the USDA, or not to the USDA, to the FDIC, and fill out a complaint and say, look, this is what they gave me. It doesn't do what the law says, and, see what they had to say. Or I'd like JD to go, file charges and specifications for fraud against the United States. Because that's who's supposed to be doing this, and they're not, so it's a fraud against the United States, JD. The usurpers that call themselves the Congress and the legal system and the executive branch, they're all esquires. An esquire is a crown agent. You can't get around it. We've been invaded by the crown, JD. The United States of America is a dominion of King George III and his successors. It's not the United States. Just a couple more things on here, JD, and we'll get on to the actuarial method about how the APR is created. We're almost there. So anyways, back to this. So we're going to go on. What else is supposed to be on here? Well, the finance charge, not itemized, using that term. Doesn't really define what the finance charge is, but whatever it is, not itemized, using that term, is supposed to be on there. And if we look at our document, we could say, well, there's the finance charge. And so they're saying that the dollar amount the credit will cost you. So the amount financed then is the amount of credit provided to you. So you're going to get 133,000 credits for $215,493. That's how I say it reads, just by what it says in the blocks. Now, we're going to find out that actuarially, that is not what's going on. There's some voodoo math going on in the background. But this goes on then to say the finance charge expressed as an annual percentage rate. So hang on, that this finance charge in 3, now we're going to express as an annual percentage rate. I'm not really sure how you do that. How do you take a number and express it as a percentage? Because there's an annual percentage rate. The cost of your credit as a yearly rate. Well, okay, well, this is the cost of the credit over here, so I guess it's the same, but now they're showing it as some percentage, or that's what they want you to believe. And then we have the sum of the amounts financed and the finance charge, which would be termed total of payments. Do we have that on here? Well, we got total of payments, the amount you will have paid after you have made all the payments. So they're saying we'll take the amount here and add it to this and put it in that box. That just seems odd. Why would I add them together? I'm going to pay you $215,000 for 133 credits. 133,000 credits. That's the deal as far as I'm concerned. Why would I pay you back again? I'm just going to pay you the $215,000. But that isn't what they meant. This is on top of paying them back the $133,000. So you can already see, well, actually your interest rate's over 100% that you're going to pay back, because you're going to pay this and this. And just one last one, the number, amount, and due dates or period of payment scheduled to repay the total of payments. And that's what we were looking at before. Okay, so what's supposed to go in here? Well, that can't be the due date for all of them. And it could have said on some particular day of the month or something like that, but they put a date in there, and so it's as wrong as rain. It's wrong, and this no money has been allocated to anybody, so apparently there's some fraud going on. Because I know the homeowner, they've been making these payments of $764, or, now looking at it, well, they're making whatever the bill says. You can't blame somebody for, not paying, not doing what the bill says. It said, here, send this much. So then so now you think about it, well, if it was actually a different number and you sent this much, then you did not send enough to cover the bill, and shit's going to start going into different accounts, because we're going to invoke the actuarial method now. And I had found this interesting. This was talking about the rules of 78 at one point, so I went on Google to see what that was. And I found this thing written by Transactions of the Society of Actuaries. Okay, well, they're the ones that are responsible for the actuarial method, so maybe we should see what they have to say about what the rule of 78 is, and so forth and so on. And it's also known as sum of digits, balance of digits. It's a technique for determining how much of a pre-computed finance charge is earned by the creditor from time to time, in particular at the end of each installment period, during the term of a closed-end credit transaction, which is repayable in equal periodic installments, usually monthly. Well, that sounds a lot like a mortgage. And then you find out, and here you read a little bit farther, it says, well, it's been prohibited. But it's only been prohibited in mortgage refinancings, so not in a mortgage necessarily. And then for the purpose of calculating a refund of interest is what it can't be used for. But it's used for a lot of different things. It's the actuarial method is what it is. It's just used for different things. What are you trying to calculate? Here's the method to calculate it. And So let's just real quick look at what their explanation of this means, right? So first, make sure that they tell you there's a legal distinction between a loan of money and an installment purchase of goods. The credit transactions illustrated in this paper use terms associated with the installment purchase of goods. It should be understood that the same principles apply for a loan of money. Well, you're going to see that the terms being used are the same terms that are on the document that we're talking about, because we did a credit transaction. There was never a loan for money. It was a credit transaction. Installment purchase of goods. That was what your house purchase was. It was never a loan of money. Couldn't have been. You and the bank never signed anything. I don't believe there could be anything because you and the bank didn't sign anything, but there certainly couldn't have been a loan of money because that would have required a contract. Well, they're not even calling this a contract. We're just calling it a credit transaction. And so you got your unpaid balance. So what they're trying to do is they wanted to set up an example that had 12 monthly installment payments of $100, and they, worked their formula backwards to come up with these numbers. So the unpaid balance, we're going to say somebody owed $1,064.23, and then we got to put some insurance on. Well, that's going to be the amount financed, right? That's the same then as the amount financed, $133. Okay, good. Then we got the finance charge. Well, let's see what that is. We got a finance charge. Yeah? So we got the amount financed and the finance charge. Those two things are the same in the Rule 78 proceedings. And then we got the total amount payable, which is the sum of 3 and 4. Okay, so the amount financed and the charge is the total amount payable. Well, then it goes on to say the annual percentage rate is 21.5%. Well, how can it be 21.5%? If we're going to pay this off in a year, and there's a $100 payment for 12 payments on a $1,000 note, it was more like 12% a year. In fact, they talk about that line 4, which is the charge, is pre-computed finance charge for the whole term of the indebtedness, calculated rate of 12 per 100, Could come up with this number. And the number that comes up afterwards, that's known as the initial indebtedness. So that's how much I have as a debt at the beginning. That's going to, just a second, I'll show you where that comes in. But then we got 6 calculated by the actuarial method defined later. There you go. Annual percentage rate. They're going to use the actuarial method to take a 12% loan for a year and turn it into a 21.46% loan for a year. Well, how in the hell are they going to do that? Let's find out. But then this goes on. So upon completion of the credit transaction, the creditor might set up his books as shown in the accompanying tabulation. So we got all these months, and we have all these different things. Got outstanding indebtedness, monthly payments, da-da-da. Well, look at, so month 1, you got an outstanding indebtedness of $1,200. But after a year, you have an outstanding indebtedness of $7,800. And no payments have been made. Right, this is going to go in the creditor's book. So when we see this thing that looks like the debt clock, if that's the creditor's book, when you pay off a $1,200 debt, it's going to show up as in the debt clock as a $7,800 debt still, because it's an outstanding indebtedness. It's like this is like compounding debt. Forget the compounding interest. The interest has already been figured out. So they're just compounding the debt. First it was 12, now it's 11, now it's 1,000, now it's 900, all the way down to you come up, add them together, $7,800. That was the total debt. For a finance charge of $128.57 and a credit life premium earned is $7.20. That's the actuarial method. That just doesn't seem very fair to me, JD. How about you? It goes on to say the Rule 78 is a method of apportioning the total gross income from the pre-computed finance charge or from credit life premium to each installment period in a way that recognizes the declining nature of the indebtedness. Well, no, it doesn't. It doesn't decline because it's got 7,800 under here, so that's saying the total indebtedness. It started as 1,200. How could it have declined? Anyway, so they're going to use that, right, which is 12 over 78, and divide that into that fraction into the amount of the finance charge. And say, well, in the first month it's 1978. Next month it'll be 11 over 78 divided into 127. And I have another number going down, dot, 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 dot. Each of these numbers going down. But at the end of the day, the outstanding indebtedness, according to this, the total, because it says outstanding indebtedness, this is the book somewhere. The outstanding indebtedness from a $1,200 debt that's been paid off is $7,800. We'll put that on the debt clock and see if that reduces the debt any. Let's just, quit using voodoo math and figure out what the number is. Okay, and just a little bit further, then we get to the real meat and potatoes here, the actuarial method, which is prescribed for the use in determining annual percentage rate for truth in lending purposes. This method is not defined explicitly in federal law. However, it is defined implicitly as follows. Now, we can need to stop there and say, well, apparently there's a difference between explicit and implicit, and I feel it a duty to show you what they are, so give me a second. So the actuarial method is not explicitly defined in federal law, which means it's not literally unfolded, hence plain in language, open to understanding, clear, not obscure. These are the things it's not. Right? Expressed, not merely implied, plain, open, clear. So that's what it's not. Well, then it says it is implicit. So what does that mean? It means implied, tactically compromised, or comprised, fairly to be understood, though not expressed in words as an implicit contract. Well, that's bullshit. I want it in words. It's supposed to be in the law. So they don't even know what it means. It's whatever they want it to mean. Right there, the expert will tell you what it means. Resting on another, trusting the word of or authority of another without doubting or reserve. Well, I don't believe in that. Sorry. So I don't accept an implicit definition as being binding on anybody. Nevertheless, there it is. It's in section 1606 of the law we've been looking at, where it says the annual percentage rate applicable to any extension of consumer credit shall be determined. Again, I said consumer credit. I didn't say a loan of money, so you didn't borrow any money. This is all a installment purchase for goods. Consumer credit shall be determined in accordance with regulations of the board. Well, there's the board again. So we need the proper board to exist, and it doesn't, JD. Please trot on over to the General Court Martial Convenient Authority. So how about this then? So in case, so we got that part. Well, in case of an extension of credit other than under an open credit plan, right? The yield of a sum equal to the amount of the finance charge, when it's applied to the unpaid balance amount of the amount financed, calculated according to the actuarial method of allocating payments made and debt between amount finance charge, pursuant to which a payment is applied first to the accumulated finance charge, and the balance is applied to the unpaid amount financed. Okay, that sounds simple enough. So, but you'll notice that we got a comma here, and then we got a comma here. So by the law of commas, there it is, right there. We should be able to snatch that section out and not change the definition of the sentence at all. And so we don't need to calculate jack. We just need to apply the payments. So if we use that analogy and say, okay, well, on the worst case scenario on day one, I got to do something with this annual percentage rate to create a sum that's equal to the finance charge, $215,000, when it's done to this amount financed, which is $133,000. Let me show you what I mean. All right, section 1606, we'll just move it over here and say, well, in a sum, now we mean a quantity of money or currency, not necessarily adding two numbers together, although that can still be. It's just another one. One of them, a sum, is a quantity of money or currency. Right? So money must not be currency or there wouldn't be two of them. Right? Money would be a loan of money and currency must be what you use in a commercial transaction. So yield, a sum equal to the amount of the finance charge. Well, we know the finance charge is $215,493 when applied to the unpaid balance of the amount. Well, on the very worst day, it's $133,000. So that's the worst case scenario. So $133,000 times whatever X is supposed to equal $215,493. Well, you set your equation up to solve for X, and you ended up with X equals 1.62. It's basically just talking about taking the amount financed and dividing it by the, taking the finance charge and dividing it by the amount financed. Multiply by 100, and now you got 162 APR. Well, that isn't what the form says, but, according to what they just said, that's what it is. It's 162. And actually, as I remember, it was 162,499,999, right? I just cut it off, but I should have kept it. Because really, it's, if there was 10625 or 1625, right? So that's actually 106%. Or 160%, 1625. Okay, so one more time. The rate which will yield a sum equal to the amount of the finance charge, $215,493, when it is applied, what's it? Well, it is the percentage rate applied to the unpaid balance of the amount financed, which the worst case for that is $133,000, on day one. Calculate according to the actuarial method of allocating payments, yada, yada, yada. Okay. But what it said first is up to this comma. And that is, yield a sum equal to the amount of the finance charge when it's applied, the unpaid balance. And that's what happens when you apply X, which is 1.62, to 133,000. There, we can do the math. 133,000 times 1.62 is 215,460. That's close enough for government work. So, I say that I satisfied the requirement to do the numbers the way they are on day one, right? If that's what it was, and I owe 215,000, then I'm actually paying in finance charges 162% of the amount financed. That sounds like pretty steep finance charges, don't you think? I thought it was a 6% loan. I don't think so. So I guess in closing, when it comes to credit transactions, which are actually installment purchases of goods, there is no money. It's not a loan of money. It's an installment purchase of goods. That when they're doing the math, they do it this way. Because we're not talking about a loan of money. We're talking about, some other species of something, and they call it debt. So your original debt, which is $1,200, will end up being a total debt of $7,800 in a 1-year period. Well, that'll drive up the debt clock in a hurry. The quicker you pay it off, or the more you pay it off, the more in debt the country goes. So, this whole thing with the number is a fucking scam, man. It's a reason for them to raid, like, all the CAFR accounts and stuff. And this is where the real debt is. I just want to show you one, sir. Here's the D.C. Water. Outstanding indebtedness for the District of Columbia Water Service. Look at this. These are bonds for 2014, where the original principal was like $350,000, and it still is. They ain't paid a damn penny. since 2014 off of the frickin' debt. All they're doing is making interest payments. Same thing here, 100,000, the numbers haven't changed. And even the ones they've changed, it's only by a very little bit. All these are almost exactly the same number they started at. Just years and years. Go back all the way to 2010. Owed 300. How much you paid off? Well, a little, maybe $9,000. Since 2010. Well, that's not going to get your bills paid. And so the total outstanding debt then ends up being this number down here, which is times 1,000, because it said this number is in thousands at the very beginning, right? Numbers in thousands, which makes that $3,818,204,000 or 400,000 debt. They're not dollars. They're different species. So in credit and debt ratio, it got nothing to do with a fucking dollar. A dollar is a weight of gold and silver. Or dollars with an S when you write the word out. It's a weight in gold and silver. Put little numbers in a box, well, you're talking, this kind of stuff. Okay, well, I don't have anything else to tell you, JD. That's enough. I don't know what you can do, but, brother, can you, how do we get these APR numbers, JD? When they tell you, well, you do this to come up with a number with a sum that equals the finance charge. When you apply it to the amount borrowed or the amount financed, so there's something going on, and we can't go to the CFPB to get it resolved because they're an agency. They're not a bureau. And the bureau is supposed to write legislation. And who was that bureau again? Just one last time. The Bureau of Consumer Financial Protection, JD. That's what y'all in the Congress said you wanted the bureau to be, and that is not what we have. So you should be able to impeach somebody from the Congress or impeach somebody in the Board of Governors for not following your wishes. I'll leave it at that and let you figure the rest out. Okay. Okay, y'all have a great day. We'll see you now.